The Constitutional Court has dismissed an application for leave to appeal a High Court ruling compelling the President to give reasons for hiring and firing ministers. President Ramaphosa took the matter to the Apex Court to seek clarity on the powers of the President. In 2017, the High Court ruled that the former President Jacob Zuma must give reasons for his controversial midnight cabinet reshuffle. This saw the axing of the then Finance Minister Pravin Gordhan and his deputy Mcebisi Jonas. This after the Democratic Alliance had petitioned the court.
It is ordinarily not in the interest of justice to entertain an appeal against an interlocutory order. The withdrawal of the review application, which would address the reviewability of the President's constitutional power to appoint or dismiss ministers and deputy ministers, renders it highly undesirable, and it is not in the interest of justice to entertain the application. This matter involves issues that are highly political in character. The nature of these issues demand a proper ventilation of facts attendant to them to do justice to those issues.
All right, and for more reaction on the judgment, we joined via Skype by Dr. Ntsikelelo Breakfast. Dr. Breakfast is a political analyst from the University of Stellenbosch. Doctor, good afternoon to you. Thank you so much for joining us here on SA Today. Just firstly, try to break it down for us and bring it to our understanding. Does this judgment mean that the President's prerogative to hire and fire can now be challenged?
In as much as I do appreciate what the Constitution says in terms of Section 91, that the President does have prerogative powers to appoint ministers, deputy ministers, and also to fire them. However, it must be noted that executive authority is not a blank check. It doesn't mean that because you are the head of state or the head of government, you can do as you please. Those powers which are stipulated in the Constitution are meant to be used in pursuit of national interest. Now, the predecessor of the incumbent, namely former President Zuma, he fired the former Minister of Finance alongside his deputy on the basis that there was an intelligence report. And later on, it turned out that there was nothing of the sort. So against that background, then the DA took the matter up to the High Court, and then a ruling was made that the President needs to disclose reasons for firing of ministers or deputy ministers. So I think because this matter is in the interest of the public, I think that's why the Constitutional Court had to uphold the decision of the High Court.
But again, what does the judgment really say? As much as the Constitution provides for those powers to the President to hire and fire as he wishes, does this mean that even if he was to do that, to hire and fire and reshuffle his cabinet, the decision can still be challenged?
Yes, look, everything has a context, and context is everything. There is a background to this. I think at some point there was an abuse of executive authority. There were decisions that were made not in pursuit of national interest. And maybe the concept of state capture as well comes into the picture. So I would imagine that that is what had informed the judgment of the Constitutional Court alongside the High Court.
So does now the judgment today mean that the 2017 High Court judgment on this case that was brought forward by the DA, who wanted the reasons for the sacking of the minister and his deputy, still stand?
No, of course, that judgment still stands. That's what the Chief Justice said when he was unveiling his judgment, that the judgment of the High Court is upheld by today's judgment. And I think this sets a precedent indeed that in as much as the Constitution gives the prerogative powers to the head of state, but those powers, whenever the president is using them, he needs to use them in pursuit of national interest and not use them for other reasons which have nothing to do with taking the country forward.
But at the same time, will this particular judgment not subject the president's powers or his prerogative to some sort of frivolous litigation for political gamesmanship by opposition parties, for example?
Well, on that score, I guess that's why we have the judiciary to basically resolve those conflicts or issues whenever the need arises. But from my standpoint, I think this is a good judgment because it means that whenever the head of state wants to reshuffle cabinet or fire a minister or anything of the sort, he needs to take into account the interest of the state and not do that in pursuit of self-gratification.
I think in return, it also raises questions around the validity of the decisions made by the president, who then determines the validity of the reasons to hire and fire ministers, because what may be valid to you may not necessarily be valid to me.
No, I agree. I accept that. But at the same time, I think the public must be taken into confidence as to why certain decisions are made and not be misled by information that is invalid. Like I said to you earlier on, there was information that was unveiled in public that the reason why the president had fired the former minister of finance was due to an intelligence report. And later on, we found out that there was nothing of the sort. There was no such. And I think that is the basis of today's judgment. And also, I suppose that is what had informed the previous judgment of the High Court.
From what you're telling us, Dr. Breakfast, would one be correct to say now this judgment basically gives the people the power to veto the president's decision?
Look, we live in a democracy, and we've got a separation of powers. So the executive is separate from the judiciary. I think the other thing that we are not talking about is the fact that today's judgment is also an antithesis of a narrative that has been circulating around that the president has some kind of a strong political footprint in the judiciary, in the sense that he's got a henchman or the judiciary is captured. Because had the judiciary been captured, there is no way they would have ruled against his appeal. So I think that argument also falls away, that we've got a vibrant judiciary. If anything needs to be questioned, it can be brought before the attention of the judiciary.
It would be interesting to see what happens going forward, but time constraints, we'll leave it at this for today. Thank you so much for coming through, Dr. Ntsikelelo Breakfast, a political analyst from the University of Stellenbosch, trying to help us to make sense of the Constitutional Court ruling.